This is Barry Zelma, speaking for Zelma on Insurance on YouTube. I am an attorney who has retired from the practice of law, but I work full-time as an insurance claims consultant, an insurance claims and bad faith expert witness, an author and producer of these videos. Today, in conjunction with my blog, Zelma on Insurance, which is at www.zelma.com/blog, I am going to read from the post today, which is titled, Hallelujah! Texas Allows a Fraud Exception to the 8 Corners Rule. Finding a chink in the 8 corners rule is essential to bringing Texas into the 21st century with regard to interpretation of insurance coverage and the duty to defend. The 8 corners rule of insurance contract interpretation about the duty to defend directs Texas courts to determine a liability insurer's duty to defend its insured based upon 1, the pleadings against the insured, and 2, the terms of the insurance policy. For many years, plaintiffs' lawyers have taken advantage of the rule and with careful pleading have required insurers to defend a suit that was probably not covered by the policy of insurance. In Loya Insurance Company versus Osbaldo Hurtado Avalos and Antonio Hurtado as assignees of Karla Flores Guevara, the Supreme Court of Texas on May 1st, 2020, ruled that in the case of an obvious fraud, it was asked to create an exception to the 8 corners rule, and in fact did so. Loya Insurance Company, the insurer, sold an automobile liability insurance policy to Karla Flores Guevara. Guevara's husband, Rodolfo Flores, was explicitly excluded from the policy's coverage. While moving Guevara's car, Flores collided with another car carrying the Hurtados. The Hurtados, Guevara and Flores, agreed to tell both the responding police officer and the insurer that Guevara was driving the car rather than Flores, so their injuries could be paid for by the insurer. The Hurtados sued Guevara, sought coverage from the insurer claiming damages resulting from Guevara's negligent operation of her vehicle. The insurer furnished an attorney to defend Guevara. Early in the discovery process, Guevara, apparently feeling guilt, disclosed the lie to her attorney and identified Flores as the driver. The insurer responded to this information by denying her both a defense and coverage. The trial court granted the Hurtados' motion for summary judgment and rendered judgment against Guevara, awarding the Hurtados $450,343.34. Guevara assigned her rights against the insurer to the Hurtados. The Hurtados then sued the insurer, alleging its denial of a defense and coverage was negligent, breached the insurance contract, breached the duty of good faith and fair dealing, and violated the Texas Deceptive Trade Practices Consumer Protection Act, the DTPA. The insurer deposed Guevara, who recanted her initial statement that she rather than Flores was driving. The trial court granted summary judgment for the insurer, remarking at the hearing on the motion that the Hurtados were, quote, asking this court to ignore every rule of justice and help them perpetrate a fraud, close quote. The Court of Appeals, faced with Supreme Court precedent about the 8 corners rule, held that, as logically contrary as it may seem, the insurer had a duty to defend under the Eight Corners Rule. One justice concurred in this judgment, urging the Supreme Court to adopt a narrow exception to the Eight Corners Rule for instances of undisputed fraud and collusion designed solely to create a duty to defend. In conducting its analysis, the Supreme Court stated that the duty to defend, of course, is a contract creature arising from a liability insurer's agreement to defend its insured against claims or suits seeking damages covered by the policy. Generally, only the four corners of the policy and the four corners of the petition against the insured are relevant in deciding whether the duty applies. Under this Eight Corners Rule, a court should not consider extrinsic evidence from either the insurer or the insured that contradicts the allegations of the underlying petition. Twice in its history, the Supreme Court noted that collusive fraud by the insured might provide the basis for an exception. As to falsity, there is no dispute on the record regarding who was driving the vehicle that collided with the Hurtados. The evidence showed conclusively that the insured Guevara was not driving. An excluded driver, her husband, was. There is no dispute regarding whether the Hurtados agreed with Guevara and her husband to make false statements about who was driving in order to trigger Guevara's insurance coverage and the insurer's duty to defend. To the contrary, given Guevara's own admissions under oath in the suit, the record shows conclusively that these parties to the underlying case conspired to lie about who was driving to trigger insurance coverage. Given the contractual foundation of the Eight Corners Rule, the Supreme Court concluded it does not bar courts from considering such extrinsic evidence regarding collusive fraud by the insured in determining the insurer's duty to defend. Neither Loya nor any insurer agreed to undertake, and the insured did not pay for, a duty to defend the insured against fraudulent allegations brought about by the insured itself. When there is conclusive evidence that groundless, false, or fraudulent claims against the insured have been manipulated by the insured's own hands in order to secure a defense and coverage where they would not otherwise exist, then there must be an exception to the Four Corners Rule. So when confronted with undisputed evidence of collusive fraud, an insurer can simply deny the claim and need not pursue a declaratory judgment action to determine its duty to defend before terminating its representation. The Hurtados contend the Supreme Court should require an insurer to obtain a declaration that it has no duty to defend its insured before it may withdraw the defense. But an insurer faced with undisputed evidence of collusive fraud should not be required to pursue a declaratory judgment action before withdrawing its defense for two reasons. First, an insurer in this position could well conclude there's no justiciable controversy between it and its insured to support a declaratory judgment action. Second, an insurer that breaches its duty to defend by withdrawing can be held liable for substantial damages and attorney's fees, which will help ensure that an insurer withdraws its defense without first securing a declaratory judgment only in clear-cut cases. Since the Eight Corners Rule was put in place, the state has provided multiple ways for an insured to sue and obtain massive damages from an insurer that wrongfully refuses a defense. These consequences, among others, are adequate to ensure that insurers will seek a favorable declaratory judgment before withdrawing a defense in most cases where there is a real controversy regarding the duty to defend. The Supreme Court continued to encourage insurers to take that course. To address such cases of collusive fraud, the Texas Supreme Court adopted an exception to the Eight Corners rule. Courts may consider extrinsic evidence regarding whether the insured and a third party suing the insured colluded to make false representations of fact in that suit for the purpose of securing a defense and coverage where they would not otherwise exist. If the insurer conclusively proves such a collusive fraud, it owes no duty to defend. An insurer confronted with undisputed evidence of collusive fraud may choose to withdraw its defense without first seeking declaratory judgment, though it risks substantial liability if its view of the duty to defend proves wrong. My opinion is that it is about time that the state of Texas created an exception to the Eight Corners rule. Hopefully, this decision will lead to others, allowing the admission of extrinsic evidence to determine the duty to defend, as has the state of California and other states. Remember, a careful lawyer drafting a suit can always allege something that will allow for a defense. Consider my blog post on how a murderer's estate got a defense when he shot the plaintiff in, quote, Four Corners rule requires defense for a person who shot plaintiff in the face, close quote, at my blog, http://zalma.com/blog, and do a search for the Four Corners rule. This video was adapted from a blog post at zalma.com/blog, and it is made as a video because it's important to changing the Four Corners rule, which has caused serious difficulties for the insurance industry and allowed people who have no coverage to use the wisdom of a bright lawyer to allege something that would get them a defense and eventually a settlement. If you found this video to be of use or of interest, please subscribe to my YouTube channel so you can learn about other videos as they are produced daily. Thank you again for your attention.